Small fiber neuropathy and a disability insurance claim by a cardiothoracic surgical physician's assistant. Small fiber neuropathy can make it difficult to stand and walk, and that can be a problem if your occupation requires constant standing or walking. Now, you would think that this would be a no-brainer for a short and long-term disability carrier, but dealing with Liberty Life can be tough. So let me tell you the story of Mark Taylor, who was a cardiothoracic surgical physician's assistant, found in the case of Taylor versus Liberty Life. Taylor was paid his short-term disability benefits and his own occupation benefits for 24 months. And at that point, the definition of disability changed. He was only eligible for disability benefits under the terms of the policy if he was unable to perform any occupation. Now, definitions are important in a disability insurance policy or plan. This policy defined any occupation as any occupation that the covered person is or becomes reasonably fitted by their education, by their experience, by their physical or mental capacity. So ultimately, his claim gets denied. What needed to be in the denial letter? Well, ERISA regulations require that a plan's administrator who's denying or terminating benefits set forth the specific reasons for such a denial, written in a manner calculated to be understood by the participant. A disability carrier has to explain why it chooses to discredit relevant evidence and provide a non-conclusory explanation of its findings. Now, in this case, the court noted that the denial letter didn't have to detail every reason in the record that was the basis of the denial, but had to provide enough information to render the decision to deny the benefits susceptible to judicial review. So how does that work? In deciding Taylor's entitlement to benefits, the court looked at the denial letter. What did the denial letter say? The information contained does not have exam findings, diagnostic tests, or other forms of medical documentation supporting the symptoms and impairment of such a severity, frequency, and duration that they'll result in restrictions and limitations that would render him unable to perform the duties of any occupation. Now, in this denial letter, they had identified other occupations that they thought he could do within his functional capacity and vocational skills. But that whole denial letter is kind of clear as mud, isn't it? What did the court do? Well, the court was using an abuse of standard discretion of review. They noted that the medical documentation from 3 primary sources included notes from an occupational therapist, a neuropsychologist, and a PCP. And at least one of those sources provided diagnostic testing results. Each of the sources had examined him at least once, and all had concluded that his neuropathy prevented him from full-time employment. Now, while the court said, look, you could take some issue with the evidence, the statement in this denial letter that the information was devoid of any exam findings, diagnostic tests, or other forms of medical documentation was wrong. The medical records, in fact, showed all of those things. So what happened, of course, was that the court focused on the conclusion that there was no evidence, when in fact there were letters from his treating physicians that documented the frequency and severity of his symptoms, documented via a functional capacity evaluation his restrictions and limitations, a neuropsychological evaluation noting there was evidence of neurocognitive impairment because of his pain, and medical documentation that made it clear that his claimed inability to return to work was the result of his physical limitations caused by the small fiber neuropathy and his cognitive impairment. So the court also noted that the denial was predicated on Liberty's referring medical professionals. I call them liar for hires. They didn't explain in their reports the specific reasons for rejecting the opinions of the treating medical providers. I think there are some reminders that we need to take into consideration. The court reminded us that a disability carrier plan does not have to accept the opinion of a treating physician. They do have to potentially give some weight to the opinions of the treating physician, but the carrier can't simply ignore the medical conclusions or dismiss these conclusions without explanation. And the explanation's got to be factually right. Unfortunately, the court remanded this back to Liberty to correct their mistake. And I say that correct. Basically, the court in this case gave Liberty a roadmap on how to legally and cleanly deny this case. This is just another reason why the arbitrary capricious standard of review puts a handcuff on a federal judge. If your claim has been denied, call me today at 727-894-3188 for a complimentary consultation. I can help you get the disability benefits you deserve, regardless of where you live in the United States.